Hello and welcome. This video is part of our series on restructuring, and today we're focusing on restructurings in the aviation industry. My name is Duncan Batchelor, and I lead Norton Fulbright's aviation group. I'm joined by three of my fellow partners who've all worked together on recent aviation restructurings. In London, we have Owen Mulholland, who represents a number of airline clients, and in New York, we have Fiona Henderson and David Rosenzweig, who have, like all of us, been working on US Chapter 11 restructuring. Now, since the beginning of the COVID period in 2020, there's been a large number of restructurings of airlines and even aircraft leasing companies. The first non-US airline to file for Chapter 11 bankruptcy protection in 2020 was Avianca in Colombia, which was then followed by Aeromexico, LATAM, Philippine Airlines, and now SAS. Owen, tell us the background.
On the airline side, and looking at Chapter 11, airlines such as Aeromexico, Avianca, LATAM, Philippine Airlines, and Scandinavian Airlines have all filed for Chapter 11 protection in recent times. You can see there a particular focus on the Latin American airlines, and that's perhaps because of the proximity of the US bankruptcy courts to their home markets. But with Philippine Airlines and also with Scandinavian Airlines, you can definitely see Chapter 11 perhaps gaining traction in jurisdictions and markets outside of the domestic United States and Latin America. The factors behind the decision to file will be different for each airline, but for some of those airlines who filed during the COVID pandemic, they simply had no choice. The only reason they had to seek Chapter 11 protection was the immediate and catastrophic effect of the COVID pandemic on their businesses and the complete cessation of the aviation industry in their home markets. For other airlines, the pandemic and their responses to it have exposed longer-term structural issues with their businesses, which has in turn led them to seek the protection of the US bankruptcy courts. There are, of course, alternatives to Chapter 11. In recent times, you've seen other airlines such as Virgin Atlantic, Virgin Australia, Thai, Garuda, and others file for equivalent processes. In the case of Virgin, the UK process equivalent to Chapter 11. But it's perhaps the filing of those non-US carriers for Chapter 11 bankruptcy protection that has been the most recent interesting development in the aviation restructuring space, in addition to those leasing companies that have also filed.
Yes, and as you say, even some leasing companies have been affected. I think the most notable of them was Nordic Aviation Capital, which is the largest regional aircraft lessor in the world. So they first implemented an Irish scheme of arrangement, which gave it temporary protection, but then they went through a full restructuring again using Chapter 11 in the US to restructure more than $6 billion in debt. So a significant number of non-US airlines and indeed the lessor have now restructured using Chapter 11, and it's become a benchmark for restructuring. So I think the predicted Chapter 11 outcome is often used as a reference point for financial advisors and restructuring professionals, and that informs the positions that they take when they're negotiating with counterparties. So David, why is Chapter 11 so popular?
Well, Duncan, it's popular because it is, number one, reorganization and debtor friendly. It's a regime that focuses from that angle, and it has a successful track record over many years. Number two, it has strong cram down rights against holdout classes of creditors or individual creditors that allow a drag along of those who are not yet willing to engage in a consensual deal. In addition, it has strong rights of rejection of contracts and leases, which of course is one of the focuses in an airline Chapter 11 or restructuring, is to market the leases or reprofile the fleet. Third, there's a worldwide stay that at least the US courts believe applies worldwide, and most international creditors will respect that, and they generally respect all of the bankruptcy court's orders given the track record of the US Chapter 11 courts. Fourth, there's an attractive DIP financing protocol and track record that has allowed lenders and investors to lend with safety into the company. That includes a potential for loan-to-own transactions as well. Finally, I think we've seen in recent cases a growing use of mediation protocols that are set up by the bankruptcy court that allow for a consensual deal to come together, even with holdouts at the end of the process. So that's why it's popular and has become the benchmark for most restructurings worldwide. I guess the question also comes up is, well, how do these non-US companies get into Chapter 11? How is it available? And as we have learned or relearned, there is a very low bar to entry into Chapter 11. You just need an asset in the United States. You don't need your principal place of business to be here. And we see assets can be either a bank account or even the retainer held by the law firm representing the company. So it's a very low bar to entry, and we can see all these COVID era aviation cases involve non-US airlines and leasing companies.
And a lot of other jurisdictions have looked at the success of Chapter 11 and have been exploring implementing their own regimes. As Duncan and Owen mentioned, Irish and English scheme of arrangements have been looked at over the last couple of years, and we've seen some airlines and leasing companies use them. There's also local law restructuring regimes. So one of the analysis that people will do at the beginning of considering a restructuring process is which jurisdiction to go to, what the costs are, what the time is, what the likelihood of achieving the right result.
There are, however, issues that any airline opting for Chapter 11 would want to carefully consider. It's an expensive process, and one that places a huge demand on the airline's management team, who are effectively moving the entire business of the airline through the process at the same time. It's very intense and it's very demanding, but it is a process which has arguably worked for all of them, and which has a track record of achieving robust savings and reductions in debt and lease commitments that may outweigh the higher cost of Chapter 11 compared to other equivalent bankruptcy processes. Critically, to date, all of the airlines which have sought Chapter 11 protection have emerged with their balance sheets cleaned up and in a stronger position than they were in when they filed for protection.
Yeah, I think you're right. So we're now in 2023, and as you say, the airline industry looks very different from how it was in 2019 before COVID struck. So the market and the shape of it has changed globally. So obviously some regions or sectors are now performing well while others are not. So for example, the US domestic market is strong and in fact it continued to perform quite well throughout the COVID, while long-haul routes suffered. Similarly, demand has come back well in Europe, but Asian international routes are much less active, partly due to China's continued lockdown. But that's not the only change. Owen.
As already mentioned, some airlines have been through a restructuring process and cleaned up their balance sheets and cost base. As a consequence of this, they're now better placed than their competitors to capitalize on opportunities in their own home markets. We've recently seen, for example, LATAM, post-Chapter 11, confirm an expression of interest in acquiring the struggling Colombian carrier, Viva Colombia. Others have not restructured and have taken on more debt or deferred liabilities just to get through the problems caused by the pandemic. But in doing so, they've created longer-term problems for their businesses, which sooner or later are going to need to be addressed.
Yeah, so I think in the year ahead, collectively, we think there are two main reasons why we should see more aviation restructuring. So firstly, there are higher interest rates, high fuel costs, and obviously general inflation pressures, which are affecting both supply chain and airlines' cost base, but also consumer demand. Then, Fiona, the landscape more generally.
And more generally, as Owen mentioned, some airlines have restructured. The ones who've restructured are in an incredibly good competitive position. So those who haven't are maybe lagging behind. They may find that they don't have a competitive cost. They haven't had a chance to resize their fleet, so they may be at a disadvantage compared to airlines that have restructured, and that may drive them towards also going through a restructuring process.
So there's a competitive stress. So of course, COVID was a unique situation where almost all of the aviation sector was affected at the same time, and therefore creditors didn't have other options. In particular, they didn't have other remarketing alternatives for aircraft, and they didn't want to incur the costs of repossessing aircraft and then paying to store them and maintain them and insure them. David, what happened? What played out?
So this is sort of a key point in that we have a lot of legal rights regarding if you're on the lessor side or the lender side to repossess the aircraft, but it's only as good as the market. And that's really the driver. So the overall crisis in the market meant there were not a lot of homes for the aircraft. So lessors, lenders were forced to cooperate with the airline. They extended potential legal deadlines for addressing leases and aircraft loans to allow a plan to be developed, a business plan, because the market was overall depressed. So stipulations were entered into with lessors and lenders. They provided for temporary arrangements during the course of the Chapter 11 until matters could be sorted out and all parties could see what the market looked like going forward. And so we had creative arrangements made that deferred any arguments, fights, litigations over various legal positions regarding the Cape Town Treaty or other sections of the bankruptcy code, frankly. And so that was all put to the side, and parties cooperated mostly because both the airlines and the leasing and lending community needed time to address the COVID situation.
So Fiona, for non-specialists, perhaps you could just give a quick overview of what is this Cape Town Convention.
So the Cape Town Convention is an international treaty that is intended to standardize transactions involving movable property. The problem with aircraft is that they move. Not every jurisdiction has the same rules, and that creates an element of uncertainty and risk, which impacts sort of costs and certainty in financing transactions. So the treaty does sort of two main things. It creates international standards for registrations of interests, security interests, contracts of sale, leases, and other interests that can be registered internationally. And it also creates various legal remedies for default, including repossession and certain bankruptcy protections that are designed to be akin to sort of some of the protections we see in Chapter 11.
And the most important one that's referred to is, of course, Alternative A. So when ratifying the Cape Town Convention, then countries, contracting states, can make a declaration relating to insolvency proceedings, and they can declare that this Alternative A applies. And what that means is if a debtor has its business, its centre of main interest in a contracting state that has made an Alternative A declaration, then the Convention provides that in insolvency proceedings of that debtor, there'll be a specified waiting period, and that's usually 30 or 60 days, at the end of which either the debtor must cure all defaults, or the aircraft creditor, i.e. the creditor holding these international interests, must be allowed to repossess their assets. Alternative A also provides that the debtor's obligations can't be modified if the creditor hasn't been allowed to repossess their aircraft. So this is effectively a protection against being crammed down if the debtor won't return the aircraft. So in the current landscape, as we were just discussing, because different markets and sectors have now recovered, and because several airlines have already restructured their debts, we think that creditors' reactions might well be very different in any new restructuring. So first of all, aircraft finance and leasing creditors may have other options to release and sell aircraft, and they may not want to be forced into a time-consuming restructuring. And as Owen mentioned, it's something that can take up a lot of management time. Although the restructuring, of course, can still deal with any financial claims for deficiencies or losses, even if aircraft are recovered. Owen.
As Duncan's mentioned, airlines will therefore need to plan carefully and early before beginning any restructuring process. They will, for example, need to consider carefully if it's worth even attempting a consensual restructuring ahead of a formal court process. They may find that some lessors are more willing to engage with the reality of a formal insolvency process rather than continuing consensual discussions with them. Other lessors may well take their lead from how their competitors react to an airline that has filed for protection. And we find typically that once an airline files and concludes its first restructured lease commitment with the lessor, momentum can start to build. Some leasing companies will not want to be the outlier when it comes to striking deals with the airline, and will fall into line when the airline starts to strike deals with their competitors. As we've already mentioned, from the airline's perspective, the challenge is for the airline moving its entire business through a process, which ultimately depends upon court approval, and faces the constant risk of challenge and objections from creditors, should also not be underestimated. And that's in addition to wider issues, such as dealing with unions, which Fiona will now expand on.
As well as dealing with their fleet, during the restructuring process, airlines will also look at their wider contracts. That will include their real estate, that will employee contracts, contracts with unions, and we've seen that Chapter 11 has been pretty successful in being able to restructure some of those arrangements to again increase the competitive advantage of the airline.
So because of this different situation, we think that choices for debtors and creditors will depend now much more on the individual circumstances of their deals or of their assets or of their business.
A lot of factors go into deciding how airlines are going to resize their fleet. Deal economics will obviously be important, what the rents are under each of the individual leases, what they can market to market, what lessors will accept by way of cost reductions. The structure of the leases can also be important. For example, we've seen a lot of cases that airlines where they pay maintenance reserves, they've wanted to replace that with an end of lease adjustment. If there's security deposits or other cash payments, they may want to replace that with LCs, or they may prefer leases that already have those arrangements in place. The maintenance status of the individual aircraft is also incredibly important. When the next big maintenance events are coming up, what costs are involved with continuing to run those aircraft? And in today's environment, the efficiency of the aircraft is increasingly important, whether it's the newer, more efficient aircraft or whether it's the older, less efficient, burns more fuel and more expensive to run, as well as the PST considerations.
Debtors and creditors will also want to look carefully at the remarketing alternatives for their aircraft. The contrast between where we are now and where both debtors and creditors were during the pandemic is stark. For the right assets, creditors have choices in a way that they did not have in the midst of the pandemic. Competitor airlines in the same region as an insolvent operator could well be an attractive option for a creditor looking to place its aircraft elsewhere. And for the right type of asset, such as the fuel-efficient, narrow-body aircraft that almost every airline in the world wants, there could well be options in other parts of the world and other markets. In making that determination, creditors will want to consider where their assets fit in the overall business plan of the insolvent airline, and the airline's business plan generally post-restructuring. They will want to look carefully at where the insolvent operator will sit in its market post-restructuring in light of continued competition.
That's why we think that in this new environment, the decision-making is going to be more granular, both for debtors and for creditors, and that therefore Alternative A under the Cape Town Convention could become more relevant now and could be tested in the year ahead. Now, David, according to the Cape Town Convention, the creditor's Alternative A rights should be respected as long as the debtor's own jurisdiction chose Alternative A, even if the insolvency proceedings themselves are being held in a third country, such as the United States, which did not make an Alternative A declaration, as long as that country itself is a contracting state. Now, how could that play out in a Chapter 11 case?
Well, Duncan, you're right. That's the structure of Alternative A. It has not been tested in the U.S. Chapter 11 context to date yet. Given the situation with COVID and its overall effect on the market, it didn't need to be tested, and no one really was in the mood to test it. That may change. However, what we see basically generally in the U.S. Chapter 11 context is a reorganization-friendly, a debtor-friendly process. And so while there are, I guess, lessor views very strongly that Alternative A should apply, we do have to acknowledge that in that situation of a Chapter 11, a bankruptcy judge is probably not all that familiar with Cape Town or Alternative A, and they're generally looking to lean towards finding a way to assist the reorganization. So it's out there. There probably will be a test coming in down the line in some case, but it hasn't happened yet. Just to give you an example of the reorganization-friendly attitude that may exist, we can look elsewhere to Australia, where there was a decision in the Virgin Australian Airline Administration that pertained to the rights under Alternative A and what the airline had to do to, quote, give possession of the aircraft once it had been rejected. And there the courts held that basically all the airline had to do was make the aircraft available as is, where is, without any return protocol at all. Now, the courts in Australia used the Chapter 11 law and case law related to 1110 to come to that conclusion, but they didn't go the full route, because the cases under Section 1110, while not requiring lease return conditions to be complied with, do have a reasonableness standard that has to be met. The court in Australia did not go there at all and just said, lessor, come and get it where it is. So that's just an example of the reorganization or debtor-friendly attitude that courts may have in restructuring proceedings.
Okay, thank you. So to summarize then, I think companies and creditors are going to need to plan carefully, and sometimes they may need to react very quickly within prescribed time periods, and there may well be a test of this Alternative A.
Right. The outcomes are not going to be as predictable, probably in the future cases, future restructuring cases, because the market will be different, and I think lessors and lenders will likely be more interested in remarketing the aircraft, and thus there probably will be more options available to them and more litigation as a result in the bankruptcy cases, or at least the Chapter 11 cases here, where alternative A may now become a point to be taken and pressed.
Thank you, David, and thank you as well, Fiona and Owen. This is a complex area and one in which we expect to see developments in the year ahead. In the meantime, if anyone watching has questions about aviation restructuring or any of these issues, please feel free to contact us. Our details are on the Norton Rose Fulbright website. But for now, thank you for watching and goodbye.